Hello, everyone, and welcome. And thank you for joining us for an MP Wired for HR webinar featuring the 2024 HR Year in Review and a glance into 2025. I'm Katie Kreider, Marketing Manager here at MP. For those of you joining us on a webinar for the first time, MP combines cutting-edge, user-friendly HCM software with proactive white glove customer support, recruitment process outsourcing, and HR services that keep business leaders abreast of the latest HR updates and compliance requirements. I am thrilled to introduce your expert for today's webinar, Paul Corellis. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM certified HR professionals here at MP, and together they assist clients with compliance, training, and HR guidance and a full support for the full employee lifecycle. Just a few housekeeping issues before we get here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will have an FAQ question at the end that Paul will be answering your questions. We will also be sending out the recording of the presentation sending out a recording of the webinar and presentation slides after. Thank you, everyone. Now over.
Thanks so much, Katie. Hope everybody's having a great day. Also hope the weather's a little bit better where you are versus where I am. It's a cold and rainy and windy December day here, but excited nonetheless to be speaking with you all. This is one of my favorite sessions of the year, getting to kind of look back at 2024. What were the significant legal and compliance and best practice changes that occurred, and especially this year with a lot of change obviously happening in Washington, what we might be able to expect or predict may happen in 2025. Admittedly, a tough thing to predict right now based on where we're at, but we'll take a stab at it anyway. So in terms of what we'll be covering in this session, we'll go over several kind of HR headlines, but we'll talk about the federal overtime rule and changes to the Fair Labor Standards Act, both real and proposed. We'll also dive in a little bit, just with so much kind of getting changed and thrown out. I just want to make sure everybody's clear on what is still intact and what the expectations and requirements still are with the Fair Labor Standards Act. What the new presidency may bring from an HR perspective. We'll go over some employer trends, what we're seeing out there as we work with businesses and look at case studies and court cases and kind of what we're seeing as trends across the employment space. We'll talk about some items on the Supreme Court's agenda for this upcoming session, as well as some other significant court rulings. Then we'll do a state law roundup. There were several ballot initiatives and other actions taken at the state level that may impact you depending where you have employees. And as always, as Katie mentioned, we try our best to leave some time for questions. So if you do have any, don't be shy. Feel free to throw those into the Q&A feature within Zoom. And with that, let's kick things off. So I know not everybody has the attention span. I can definitely relate to that, to take a full hour's worth of information and be able to digest it all. So I wanted to do some kind of quick hits of some significant stuff. First, in terms of the Affordable Care Act, or the ACA, what we're seeing out there is a dramatic ramping up of ACA enforcement. In previous years, inquiry letters, audit letters, any type of inquiry related to ACA from the IRS had been pretty sparse, but we've just seen a deluge of businesses get letters, some of them with proposed amounts and penalties, some of them really just kind of fishing to say, hey, it looks like in 2021 you had more than 50 employees. We don't really have any way of knowing what your full-time equivalent count was. So we're just going to cast this out there and let us know and prove to us whether or not you should have been subject to the ACA. So some of these are just kind of fact-finding missions, it seems. Some they know or feel that they're confident that a business should have filed and maybe didn't complete their filing requirements for the Affordable Care Act, but we're seeing a ton of it. A ton, especially in home health and other similar type industries, hospitality, places that tend to have high employee counts and may not actually have that many people eligible for benefits. They may have a lot of part-timers, per diems, temporary folks, and things like that, but they're casting a wide net and seeing what they pull in here. So if you feel, I'd say especially back to 2020 and 2021 is what they're looking at right now. If dating back to that time, you feel there may have been some missteps with your ACA compliance, definitely talk to us or talk to someone trusted that might be able to help you strategize on what the best plan is. In some cases, it's best to get into compliance before you receive one of those letters. Certainly, if you do receive a letter, you're going to want to reach out. Don't panic. A lot of times, I don't think I've ever seen an ACA letter that was accurate when they did have a figure there in terms of what a business might owe. It's always been overstated. So even if you feel you may be in trouble and may need something, we've been able to work with a lot of businesses to mitigate those expenses. So feel free to reach out if you do have ACA concerns. Over on the employee retention tax credit, something we've been talking about for several years. Those of you who have been waiting for checks to come in the mail, you've probably been waiting a long, long time because there was that moratorium on the refund checks from the IRS that went from September of 2023 and didn't resume until August of this year. So over the last couple months, have seen the IRS resume processing funds for ERTC claims. So that is the good news. If anyone's waiting and nervous about that, they have started a stream of refunds again. But there are certainly many, many, many businesses still waiting for those, but there is reason to be optimistic about that. Another big HR headline and an employer trend we're seeing is a big, what I call the big callback. So many companies, many noteworthy companies, including Amazon and folks like that, are going to be requiring employees to come back in the office. Certainly a controversial decision. Each company has its own reasoning for it. Sometimes they feel that they're not getting the productivity they could be if folks are in the office. That remains to be seen. Others are, actually hoping for some attrition, hoping that people will leave as a result of this and be able to avoid, layoffs or reduction in force, things like that. But we're seeing it with several companies looking to get people back in office either full time or more than they are currently. One thing that is becoming a factor, and we'll talk about this in a couple other segments in this presentation, the Equal Employment Opportunity Commission is kind of being a stick in the mud with some of these plans for certain employees. So whether it be the Pregnant Workers Fairness Act that we're going to talk about in depth in a few minutes, or an Americans with Disabilities Act accommodation, in many cases, we're finding that the EEOC is considering remote work a reasonable accommodation for many, many roles. And especially coming out of COVID, where a lot of these people may have been able to prove that the work could be done remotely. If there is a qualifying reason and it makes sense from a reasonable accommodation standpoint, the government is kind of putting that expectation out there that it's at least something to explore. And we did recently see a big EEOC judgment that found that a company violated a worker's rights by not providing remote work as an accommodation. So it is something to consider if you do get that request. Artificial intelligence, we're going to be having a whole separate webinar on this topic, so I won't go into too many details with it, but we are seeing more and more businesses increase their AI adoption, but regulation is looming. Perhaps not from the federal level based on how the election went this past November. Many people and Washington insiders and experts are expecting that the AI themed executive order that President Biden released earlier this year is probably going to be either completely repealed or kind of picked apart a little bit in terms of some of the expectations placed on the federal government and on businesses when it comes to complying with AI and the threat that it can pose to people and workers and whatnot. So don't necessarily expect regulation to be coming from the federal level. They may try to expand adoption of AI and encourage usage of it, but we're seeing more and more states really consider AI regulations having to do with protecting personal data, also disclosing when AI is being used as part of the hiring process or any type of significant decision making. So keep your eyes peeled at the state level, and that can be tricky because especially if you're a multi-state employer, you got to be keeping your eye on all the different states and what they're doing. So we're certainly here for that. Keep tuning in, staying on our mailing list, keep working with us, and we'll keep you apprised of any changes or any updates when it comes to state level laws that affect employers. Few more recent ruling by the National Labor Relations Board just a month or two ago. They have determined and kind of upending a decades-long precedent that what are known as captive audience meetings are unlawful. So what a captive audience meeting is, for those of you who are unfamiliar, is when a company holds a mandatory meeting that employees are required to attend, and they share their thoughts on collective bargaining or unionization. So these will generally happen either when a company hears that there may be some rumblings of a potential unionization effort, or it might be, in the throes of a active unionization effort, or maybe it might be a contract renewal, whatever it may be. There have always been kind of strict parameters on the captive audience meetings that you could share information, but in no way could you try to coerce employees or threaten them in these captive audience meetings. There are also several states that had their own restrictions or outright bans on captive audience meetings. But this ruling affects every state from a federal perspective. And basically the argument was that just by the fact that you were having a mandatory meeting and there was potentially punishment or discipline for not attending, that in itself was coercive. So the current iteration of the National Labor Relations Board has sided against those and made them illegal for the time being. The way the National Labor Relations Board works is the majority is formed by the president in office. So as you can imagine, when the White House changes hands, there will eventually be a different majority and a different general counsel determining which cases are heard at the National Labor Relations Board level. So this change may be temporary. Also of note, there are a couple open seats on the board right now, and the Senate is not confirming President Biden's nominations for that, which means that the Trump administration's board members may be put in place earlier than presidents usually are afforded. Sometimes it can take several months before that seat is filled with the majority of the party in the White House. This time around, it may happen sooner. So keep your eyes peeled on that as well. Speaking of the ADA, I know we talked about reasonable accommodations when it comes to remote work, but overall, we're just seeing a large uptick in accommodation requests. So definitely something you want to handle delicately. It is a focus item of the Equal Employment Opportunity Commission. We'll talk about that. It's the largest source of EEOC lawsuits. We'll talk about that as well. So it's something you need to handle very carefully. It truly needs to be an interactive process, and just make sure you're working with an HR expert should you get an accommodation request or feel like you may need to enter the interactive process with an employee. One that's really fresh off the presses, and OSHA hasn't said much in terms of detail about this, but OSHA inspectors are going to be being equipped with smart glasses. So video and audio capabilities, Zoom capabilities as well, if they need to reach out or involve other experts within the OSHA department. So as they're doing safety inspections, and we don't know if this will be across the board or in select regions or with select inspectors, but it has become public that the inspectors are going to be wearing smart glasses, which may complicate safety inspections that go on in workplaces. This one is likely to have some constitutional challenges as well in terms of recording and all of that, but more on that to come in the coming weeks and months. And then the last one is, just as I said before, a little bit of uncertainty in terms of how the Trump presidency will affect employment law. Think historically, sometimes what can happen is can really create a complicated matrix of regulatory compliance issues for employers, because what can happen is we can see deregulation at the federal level, and then states correspondingly will come up with their own state level regulation. So again, if you have multiple work locations in different states, or you have remote workers in states other than the ones you normally operate in, this can make things really, really tricky as states kind of react to federal deregulation by coming up with their own rules. So should that start to happen, definitely work with us, and we'll help make sure you stay compliant. I'm sure if you follow the news at all, you've been following all the various nominations that President Trump has been making. One of them that caught some experts, especially employment law experts, off guard was the individual he named as the new Labor Secretary nominee. So this person would head up the Department of Labor, which also includes OSHA and the like. So his nominee was Lori Chavez DeRemer, who was a congresswoman from Oregon. She actually just lost a really close election this past November to a Democratic competitor. What makes this nomination interesting is that despite being a Republican, she was found to be one of the more labor-friendly Republicans in Congress. She was a co-sponsor of the PRO Act, which we talked about probably a few legislative update webinars ago, which didn't pass Congress, but would have caused some pretty widespread unionization and collective bargaining friendly policies across workplaces across the country. So she was a co-sponsor of that, also was a co-sponsor of the Freedom to Negotiate Act. So definitely seen as pro-labor. Labor unions, heads of the larger labor unions were happy with this nomination. They were suggesting it. Also, some of the less labor union friendly interest groups out there have come out against this nomination. So in terms of what her agenda will be, she obviously hasn't had to do any testifying as of yet, has not made any lengthy public statements or anything like that. So it remains to be seen how she intends to tackle the labor secretary role in Department of Labor's agenda, but an interesting pick for sure. So let's talk about the Fair Labor Standards Act and the federal overtime rule. So last month, just about a month ago, November 15th, a U.S. District Court that covers the Eastern District of Texas essentially threw out the Department of Labor's 2024 final rule that came out early this year. So what does that mean? It means that those increases to the minimum salary level that employers were going to need to pay folks in order to keep them exempt and not have to pay them overtime, those increases have been thrown out. Not just the one that was set to take effect this upcoming January 1st, it also invalidates the increase that happened this past July. The final rule also included some automatic indexing every 3 years. So in July of 2027, there was going to be an automatic bump to the minimum salary level. That's no longer going to take place. But it is important to note that otherwise, the Fair Labor Standards Act has not been completely thrown out. It is still in effect. So again, I don't want to go into too many details, but I do want to make sure everyone has a level set of information here, knowing what they do still need to comply with. We'll talk about some other changes too. There is another rule proposed by the Department of Labor that is essentially going to end the sub-minimum wage. So there was a program in place that I don't think a lot of employers took advantage of, but it basically, for employers who were employing disabled folks, they were able to file a petition for a certificate that would allow them to pay less than the federal minimum wage for hiring these disabled individuals. So what the new rule from the Department of Labor will do with that is essentially phase it out over 3 years. They will stop issuing new certificates, and for folks who are working off of current certificates, those will phase out over a 3-year period. So we'll see if that stays or not, or if that gets thrown out or taken back by the new administration. But that's one other piece affecting the Fair Labor Standards Act. So just to kind of lay it out here visually, this is kind of what the changes were set to look like. So at the beginning of this year, the minimum salary for an exempt individual was $35,568 per year, or $684 per week. That did bump up officially on July 1st to $43,888 or $844 per week, and then was set to increase again this January to $58,656 or $1128 per week. But as I said, not only did the January 1st increase get axed, but the July 1st one did too. So to be compliant as of today, you just need to be following the original number of the $684 per week. There is also a separate salary threshold for what's called highly compensated employees. So basically what this means is you don't have to scrutinize the employee's job duties as much if they're highly compensated. That number was set to go over $150,000 per year come this January, but that's going to revert back to $107,432. So basically, if someone's making that much money, you do not have to scrutinize terribly much their job duties to make sure they fit into an exemption otherwise. So just as a reminder, what you do need to be worried about and do want to make sure you're compliance with is meeting the 3 exempt requirements for someone to be exempt from having to pay overtime and having to keep records of their hours, so on and so forth. So the first is that salary level test that we were just talking about. Make sure that they're making enough money. Also, in most cases, they need to pass the salary basis test, which means that they're paid a guaranteed salary on your pay schedule. Some exceptions to that: outside sales folks do not need to be paid on a salary basis or meet a salary level. There's also a very specific computer workers exemption and a motor vehicle carrier exemption that are exceptions to this, but in most cases, you can't be paying someone hourly and treat them as exempt from overtime. And then the third one, which is always the most tricky, is the duties test. So that one, it again can be very tricky, but there are certain exemptions that an employee needs to fit into in terms of what their primary job duties are in order to be exempt from overtime. If you have any questions for that, if you're paying everyone's salary and feel like maybe all of their jobs aren't of an exempt level, we'd be happy to speak with you about that. So for those folks who are non-exempt, just make sure some of the things that factor into compensable time can be waiting time, on-call time, meal and rest periods, training time, travel time, and sleep time. So a lot of really tricky ways, especially if you have non-exempt employees, that they can hit that 40-hour weekly threshold when time and a half is triggered. So again, just be very careful with that, because despite these court changes in the courts and changes to the rules under the Fair Labor Standards Act, it did not invalidate the program by any means, and we're still seeing audits and we're still seeing fines and penalties. So be careful. Some of the common exemption mistakes that we see, again, just confusing exempt and salaried. So it's fine. You can pay folks who are non-exempt salary. You don't have to pay them hourly, but you do need to be tracking their hours, because regardless if they're paid on an hourly basis, a salary basis, a day rate, whatever it is, if that work exceeds 40 hours in a work week, even if they're paid a salary, if they're not meeting that job duties test, you need to figure out some overtime for them. In terms of the penalties, those again are still intact. So willful violations of the Fair Labor Standards Act can result in criminal prosecution, as well as fines up to $10,000. Repeated violations can be $1,000 for each violation of the FLSA. And then child labor is also under the purview of the Fair Labor Standards Act and Department of Labor. We're seeing a lot of audits on the child labor rules. Some of the ways to be careful with that are the hours that minors are working, both the number of hours per day, as well as how late into the evening they're working, especially on school weeks and school nights. There are also different sets of rules for 14 to 16-year-olds versus 14 and 15-year-olds versus 16 and 17-year-olds. So as well as what job duties they're allowed to perform at their age. So the fines for child labor violations are very, very steep. So you want to make sure you're on the right side of that as well. All right, so let's talk about the Equal Employment Opportunity Commission and what's going on over there. So myself and the HR services team, as part of our meeting cadence on Fridays, I do a EEOC roundup, because their newsroom has just been filled with press releases about all of the settlements and lawsuits and penalties and fines that they've been able to collect on employers. So every week there's a new set of folks who are having to pay big bucks for EEOC violations. Sometimes tens of thousands of dollars, sometimes hundreds of thousands of dollars, sometimes millions of dollars. So they've been very, very busy in 2024. Coming in January or February, they'll be releasing the financials, but they did recently release some of their activity for the fiscal year 2024. So in 2024, they filed 110 lawsuits. 48 of those 110 lawsuits had to do with Americans with Disabilities Act discrimination. So either not entering the interactive process, discriminating against someone based on their disability, retaliating against someone based on their disability, failing to provide reasonable accommodation, so on and so forth. Also, 22% of the 110 lawsuits had to do with what the EEOC felt was some sort of systemic discrimination or harassment issue. So not an isolated incident with one employee, that it was something that had happened to an entire class of employees or had been a historic action by this company. And then in addition to the 110 lawsuits, we are now seeing them really enforce the requirements for larger employers over 100 employees to file the EEO-1 report. So hopefully you're familiar with that. If you're not, it's an annual reporting where you report on the demographics, both ethnic demographics as well as gender demographics for your workforce, divided out by category of employment. So there were 18 businesses who were charged with not complying with their EEO-1 requirements. So there had never really been any teeth in that law. A lot of people kind of skipped on it, and we really had trouble kind of convincing them as to why they needed to do it. But now we've got that persuasion tool here in terms of the EEOC taking action on it. In addition to kind of reviewing their fiscal data, they did also kind of remind folks of what their current emphasis is and what they're looking at and what they're really enforcing. So they're taking a really close look at AI, other related technologies, and how it may be creating discriminatory practices in the workplace. They're also focusing heavily on gender discrimination and sexual orientation discrimination. We've seen a lot of cases from the EEOC in terms of trans individuals and things like that being discriminated against work. Again, they're also looking for systemic harassment. So a lot of the cases that we've gone through in our EEOC roundups on a weekly basis have had to do with managers and supervising, harassing employees for several years, management kind of turning a blind eye to it, or when people complain, those employees get terminated, things like that. So they're going after those hard. And then what I would probably say is the biggest point of emphasis for them in the remainder of this year and going into 2025 is just making sure that employers are complying with the Pregnant Workers Fairness Act. So that was passed a couple years ago. It didn't really officially take effect until this past June, but we're already seeing action on it. We're already seeing employers get in big trouble for violating that. So I know we talked about it in the last webinar we did that was a legislative update, but I think it's worth briefly going over here as well. Because we're just seeing tons of fines and tons of penalties and tons of trouble that can be avoided. So what the PWFA really does is addresses a loophole in the Americans with Disabilities Act, because as the ADA is written, pregnancy isn't considered a disability. So you'd run into situations where people were in various stages of pregnancy or childbirth or postpartum or having fertility issues, and they weren't being protected by the ADA, and the government worked to respond to that. So what it essentially does is create something similar but different from the ADA for folks at various stages of pregnancy. So in terms of the no-nos, what you must not do under the PWFA, you don't fail to make reasonable accommodations for known limitations an employee or an applicant. Again, this applies to not only your employees, but also people applying to work for you. The accommodation process does need to be interactive. You can't require them to accept an accommodation that's done outside of the interactive process if they're not keen to it. You cannot deny a promotion, a job, or hiring to someone based on their need for accommodation under the PWFA. You can't force them to take leave if there's another accommodation that can be made. You obviously can't punish or retaliate them because of them taking advantage of their rights under the PWFA, or coerce folks either. So I guess as a departure from the ADA, which can sometimes be very paperwork heavy in terms of getting doctor's notes and certifications and fitness for duties, and those certainly play a role with this as well. The way that the Pregnant Workers Fairness Act is written, and especially the way the EEOC's guidance on it for employers is written, they really, really stress a common sense approach, and just kind of want everyone to work with common sense, which is sometimes outside of how the government normally. So it's a bit refreshing, but they just say to be practical with it. So it can be hard, especially with, the doctors that folks need to see when they're, either trying to become pregnant or are pregnant and what have you. So Sometimes they say to have some patience, give some grace when it comes to getting doctor's notes and things like that. They did also list 4 specific accommodations that should generally be accepted without any need for interaction or documentation or anything like that. So allowing an employee to keep water with them and drink it as needed, allowing them to take additional restroom breaks. If their job allows them to sit, letting them sit. Um, and then also allowing them to take more frequent breaks to eat or drink. So these are presumably reasonable just on the surface, unless there's some some wild exception that wouldn't make that a reasonable accommodation. You should generally greenlight those for workers that are covered by the PWFA. Some other examples that the guidance provided are here on the screen, and we'll make sure everybody gets a copy of these slides. But as you can see here in the top of the second column, telework is listed under the official EEOC guidance under the Pregnant Workers Fairness Act. And we have seen at least one case where they've enforced that. So there was a case with a worker who, due to pregnancy, was not able to be present at the work site, but their job could be completed remotely. And so the EEOC was expecting that to be a reasonable accommodation in that case. One clear departure from the ADA with the PWFA is that under the ADA, if going through the interactive process, it's determined that there isn't a reasonable accommodation that can be made for a worker to continue to do the essential function of their job, that gives the employer the right to not have that employee in that position any longer. PWFA treats it differently just because of the nature of pregnancy, oftentimes not being the limitations not being permanent, that for what they consider temporary or something that they'll be able to do in the near future, which they've further defined as 40 weeks to coincide with the length of a typical pregnancy, that if someone isn't unable to perform some essential function of the job with or without reasonable accommodation, you still may need to accommodate them under the PWFA and keep them in their job or find other duties for them to do. So you want to, again, tread very lightly and very carefully when it comes to this act. It's new. The precedent is still being set. And as I always say to the clients that I work with, let's let other folks bear the attorney fees and the costs of being the precedent setting cases. Let's kind of see how some of this plays out and play it conservatively in the meantime. So if you should, either your managers and supervisors are hearing it or you're hearing it from an employee, they're letting you know that they're pregnant, they're letting you know that they're having any type of malady, morning sickness, back pain, whatever it may be, they don't need to formally request accommodation under the Pregnant Workers Fairness Act or use any legal jargon. If you're hearing these types of things, you need to take action and get into the interactive process as soon as reasonably possible. So that's pretty crucial. It's also important to note that I kind of alluded to it before, but I want to make sure it's clear. The PWFA covers people in all imaginable stages of the pregnancy life cycle. So that includes fertility type issues and fertility treatments. It includes, loss of pregnancy, miscarriages, things like that. It obviously includes while an employee is pregnant. It also includes time postpartum, whether they're suffering from postpartum depression, lactation concerns, things like that. All of those things fall under the purview of this law, not just the pregnancy itself. All right, so let's talk about the courts. So there have been some significant court rulings other than the overtime rule getting thrown out that do, are worth our time to discuss. So something I think we touched on very briefly in our July session was Chevron deference being thrown out. So what that essentially meant was that for the last several decades, whenever a rule from a government agency, say the Department of Labor overtime rule or a EPA environmental rule, whenever those were presented to the Supreme Court, it was expected that they were largely going to defer to that agency. It's their area of expertise. They're responsible for that rulemaking and they have that responsibility. And unless something is overtly unconstitutional, they're going to allow those agencies to perform rulemaking. There was a case known as Loper where this year that kind of got overturned and less credence was given to the government agencies to do rulemaking. And we are now reverting back to what's known as the Skidmore case, which is, I believe, 80 years old, but was kind of the previous precedent before Chevron. So what this means is that agencies, it doesn't completely strip the agencies of their ability to make rules, but it sets the court with kind of four focus areas to determine whether a rule that a government agency makes is constitutional. First is how thorough is the reasoning of that government agency in creating this rule or making this ruling? What's the validity of the reasoning that they provide? How consistent is it with how they've acted in the past and how they'll be acting in the future? And what are the factors that give them the power to be persuasive when it comes to creating law outside of the legislative branch? So it'll be really interesting in light of this to see how the Supreme Court rules on some cases in this session and in the soon to follow sessions, but we're keeping a very close eye on that. Another interesting case is called EMD Sales versus Carrera. So in that one, and the court is hearing that now, they just heard arguments on it last month. That ruling is going to be of importance because what it's basically going to do is set the bar for how scrutinized our employer is going to be in meeting the duties test for exempt employees. So what is that threshold? How many of those primary job duties need to meet the exemptions test? And what is that test going to look like? So it's going to be very careful that we take a close look at that decision once it's written and see what the bar is and how we can best advise employers on determining whether their employees are exempt or non-exempt. This could be a pretty monumental ruling coming up. Another one of interest is Medical Marijuana Incorporated versus Horn. So in this one, the plaintiff Horn was a truck driver who had obtained a product that was advertised as being a CBD product, but allegedly also had other marijuana ingredients within it. And as a truck driver, he's subject to the Federal Department of Transportation guidelines, which require drug testing. He was drug tested and he failed the drug test. So he then sued I don't know if it's the manufacturer or the provider of the product. So this will be interesting to see how liable those folks are in a situation like this. And then another significant court ruling, this was at the district level, like the overtime rule. If you remember from our previous legislative update webinar, the Federal Trade Commission had introduced a non-compete ban that was set to go in effect right around now, if I remember correctly, but that was thrown out. So there is no nationwide ban on non-compete agreements as of right now. But similar to what I was talking about before in terms of deregulation at the federal level, leading to a more complex state matrix of regulations, that is definitely the case here. There are several states that have limitations or outright bans on non-compete agreements. So before you hire someone, especially in a state you're not too familiar with, make sure you know whether or not you can issue a non-compete agreement, and if so, what the restrictions are on that. All right, and let's finally get into some state law trends. So as I said, quite a bit going on at the state law level. Mandatory sick leave has really, really taken off. Many states now have mandatory sick leave laws that require an employer to offer paid sick leave to its employees. Based on some ballot initiatives outside of the legislative process, 3 states this past November did pass mandatory sick leave laws, those being Alaska, Missouri, and Nebraska. We're also seeing changes, and usually employee-friendly changes in several other states. So Connecticut is one that's really expanding their mandatory sick leave law in the new year. Also Michigan, it's not for January 1st, I believe it's mid-February, but Michigan is also greatly expanding their sick leave law, and theirs is really tricky. There's no cap on the amount of hours that employees in Michigan can accrue in terms of sick time. There are some usage caps, in some cases up to 72 hours, and there's a really complex calculation and measurement of when employers are considered large or small, and that dictates how many paid sick hours they need to provide to their employees. So If you are a multi-state employer, it's probably worth talking to an HR professional to make sure whatever you have for sick leave or a PTO policy meets the sick leave requirements in those given states where you have employees, whether in person or remote. We're also seeing more and more states adopt paid family medical leave. So start as of 2025, there will be 16 states with some sort of formal paid family medical leave act in place, with many more states also, either having them in the legislative session, considering having on next year's ballot as a ballot initiative. Just kind of being tossed around at the state level, but I wouldn't be surprised if we're over 20 by this time next year. Also, huge growth in pay transparency laws here where I sit in Massachusetts. This coming July, the pay transparency law will be in full effect. Illinois, New Jersey, Vermont, and Minnesota also have either new or changing pay transparency laws in the new year. So keep an eye on that. Usually what it entails is including salary range information on job postings and things like that, as well as making the information accessible to certain employees in certain situations. So you're going to want to make sure you're familiar with that. We've also seen changes to child labor laws, and we've seen it on both ends. So some states have tightened up their child labor laws and made more restrictions in terms of hours and job duties and things like that. Other states, I know Indiana, I believe, is the most recent, that's going to be loosening their child labor laws a little bit in the new year to allow workers under the age of 18 to work some more hours and do some more different jobs. So familiarize yourself with that if you do hire minors. We are also seeing outside of the Pregnant Workers Fairness Act, many more pregnancy-related reproductive right related protections for individuals and employees. You may have seen New York's new paid leave law to that effect. Several other states are creating similar but different protections as well. A lot of people and a lot of folks who work in AI or who are technology companies creating AI are keeping a close eye on state houses and what states are doing in terms of those AI laws, like we spoke about at the beginning of the session. Colorado has one that's looking like it's going to be pretty strict, and that one doesn't start until 2026. But a lot of folks, especially AI companies, are probably going to need that amount of time to prepare for it. There's a pretty significant disclosure piece in that in terms of disclosing to employees when AI is being used and how it's being factored into employment related decisions. So if other states follow in Colorado's footsteps, it could be really tricky for AI technology companies to stay compliant with all the different state laws if they do have intricacies and unique factors amongst them. And for employers outside of New York, this might come as a surprise. For most folks in most states, COVID sick leave laws are a distant memory, things that went away in 2021. But for those of you who aren't aware, New York hung on to their COVID sick leave program and requirements to this day. So next July of 2025, New York will officially be sunsetting their COVID sick leave requirement for employers. So I believe they are the last one to do so. All right. All right, so that brings us to the end of our presentation. Looks like we do have a few questions here that I'd be happy to answer. How should we handle travel for non-exempt employees? Great question. So tough to answer in this setting. Be happy to speak offline about it. You got to be very careful. So in terms of travel, that can be a loaded term. If that means travel within the workday, then that definitely needs to be compensable. So I'm thinking about home health. When you have someone who's traveling from one patient's home to another, many times they're what's considered their commute. So maybe they're travel to the office, or if they're going directly to one of the homes, that first one may not be considered compensable travel time. But in most cases, the travel from one place to another throughout the workday should be compensable. You can have a different rate of pay for the travel time, but it does need to be factored into the 40 hours towards overtime and things like that. If you're thinking more about long range travel, like traveling to a conference or a meeting out of state, something like that, there are different rules. One of which has to do with the hours in the day that an employee is traveling. So in most cases for a non-exempt worker, if their travel is during their normal hours of work, even if it isn't on the normal day that they work, that's considered compensable travel time. So if someone works 9 to 5 and you have them, you know, down to another state for a conference at 10 a.m., because even if it's on a Saturday and then usually work Monday through Friday, if it's during their normal hours of their work, many times the Department of Labor will see that as compensable travel time. There are some exceptions for mass transit flights and things like that. Again, it is complex. I don't want to give too much of a blanket answer there. Be happy to talk to you offline in terms of your specific situation, but you do need to factor in travel time for non-exempt employees for sure. Another one about carryover for PTO. Um, I don't know that there are any states that require PTO carryover per se, but there are many of the states who have mandatory sick leave laws do require you to carry that over. So the why that comes up with PTO is in most, if not every case, if you have a general PTO program that provides at least as many hours as required under the mandatory sick leave law in a given state and allows it to be used for the same reasons, you're able to be compliant with the mandatory sick leave law with your PTO program, but that's where carryover comes into play because again, many times these state sick leave laws will require you to allow for carryover. So when I talk about that Michigan program that's going to be starting up in February, that one requires unlimited carryover. So having that as part of your PTO plan might be troublesome if you're looking to cap carryover. Other states have more limited carryover requirements, but again, that's on a state by state basis. If a child is under 16 years old but is a child of an owner, do they need a work permit? Do we need to withhold Social Security and Medicare? Um, the best one is that it depends. There's agricultural exemptions and things like that in other cases, and depending on how the business is organized, there are requirements, but there are some exceptions as well. So again, that's a tricky one to answer in a general sense, but many times yes, but not always is the best answer. Sorry, I don't a better, more concise answer to that. But it is something worth discussing further for sure. So it looks like those are the questions that I can best answer here. But other than that, I'll kick things back over to Katie and look forward to speaking with you next month about AI.
Thank you, Paul. Um, thank you all for joining our webinar today, and we appreciate everyone. We will be sending out a recording and the presentation slides this afternoon. Like Paul said, make sure you join us for our upcoming webinar happening next month on AI and what that means for you all. So you can join us on our website, mp-hr.com. Thank you all and have a terrific day.